Good morning. I'm Gary DeWaal, and this is Bridging the Week for March 28th to April 1st, and today is April 4th, 2016. The U.S. Government Accountability Office has again raised issues regarding the complexity and overlap of the U.S. financial regulatory system. Separately, a commissioner of the Commodity Futures Trading Commission called for, quote-unquote, do no harm approach to regulation in order to not inhibit the evolution of blockchain and distributed ledger technologies. In addition, the European Securities and Markets Authority fined, for the first time, a trade repository for allegedly not having systems to permit regulators immediate and direct access to derivatives trading data. The New York Yankees open their season tonight at Yankee Stadium. So readers here in New York City can get there on time. Let's get started. Last week, the U.S. Government Accountability Office reported that U.S. oversight of financial services entities and products has not meaningfully improved since its issuance of a comprehensive study more than 7 years ago that warned that the U.S. financial regulatory system, quote, appears to be ill-suited to meet the nation's needs in the 21st century, end of quote, because of its high level of complexity and overlap. Last week, said GAO in a new study, the U.S. financial regulatory system continues to be, quote, complex, with responsibilities fragmented among multiple agencies that have overlapping authorities, end of quote. GAO noted that the 2010 Dodd-Frank Wall Street Reform and Consumer Protection Act introduced a number of reforms to improve coordination among financial regulators. These included the establishment of the Financial Industry Oversight Council and the Office of Financial Research. However, said GAO, quote, collaborative efforts have not been sufficient, and FSOC's authorities are limited and unclear, end of quote. According to GAO, this has caused, quote, inefficiencies in regulatory processes, inconsistencies in how regulators oversee similar types of institutions, and differences in the levels of protection afforded to consumers, end of quote. GAO identified inconsistencies in the examination of depository institutions by different regulators, the lack of uniformity in insurance regulation, and the sometimes duplicative and inconsistent regulation of securities and derivatives market participants by different regulators as prime examples of problematic oversight. Let's see the follow-up from this report. My guess, sadly, is nothing will happen. J. Christopher Giancarlo, Commissioner of the Commodity Futures Trading Commission, called for regulators, including the CFTC, to, quote-unquote, do no harm in permitting the new blockchain or distributed ledger technologies to develop. In case you don't know, distributed ledger technology, introduced in connection with transactions involving Bitcoin, references a public ledger of all transactions, referencing an item that is automatically updated to include the latest in all prior transactions. A distributed ledger technology should not be subject to tampering or independent revision. According to Mr. Giancarlo, the model for a do-no-harm regulatory approach is the approach regulators took during the initial days of the Internet. According to Mr. Giancarlo, back in the 1990s, quote, a Republican Congress and the Clinton administration established a set of foundational principles. The Internet was to progress through human social interaction, voluntary contractual relations, and free market. Government and regulators were not to harm the Internet's continuing evolution, end of quote. As a result of this approach, claimed Mr. Giancarlo, the Internet flourished, quote, created jobs, increased productivity, and fostered innovation and consumer choice, end of quote. Mr. Giancarlo argued that by following the same approach now, the distributed ledger technology can most effectively be permitted to evolve in a similar fashion. To accomplish this, the U.S. and foreign regulators should, quote, coordinate to create principles-based approach for DLT oversight in order to provide the flexibility, certainty, and harmonization necessary for this technology to flourish, end of quote. The CFTC itself, said Mr. Giancarlo, should examine and revise its rules, such as its record-keeping requirements, to ensure they are technologically neutral to avoid inhibiting DLT development. Hopefully, Mr. Giancarlo's words are considered more seriously than the GAO study. The European Securities and Markets Authority brought its first legal action against a trade repository for allegedly failing to institute systems able to provide regulators with direct and immediate access to derivatives trading data as required by applicable regulation. The trade repository was DTCC Derivatives Repository Limited, which was fined €64,000 by ESMA for committing the alleged violations from March 21, 2014 through December 15, 2014. According to ESMA, DTCC also failed to advise ESMA in a, quote, timely manner, end the quote, of the delays it was experiencing once it was aware of its system's deficiencies, and did not put in place an adequate action plan to fix its issues for 3 months. DTCC may, within 2 months, file an appeal of ESMA's decision to the Board of Appeals of the European Supervisory Authorities. And finally, CME Group resolved 8 disciplinary actions involving alleged violations of exchange-related position requirements by assessment of aggregate fines totaling $174,500 US. In many of the actions, the alleged violation involved only one transaction. For these matters, the defendant was assessed a fine of $15,000 US. 6 of the actions were against non-members, while only 2 involved members. In most of the matters, the defendant was charged with entering into an EFRP without a bona fide transaction involving a transfer of a related position, such as a transfer of the cash commodity. Separately, ICE Futures US agreed to resolve allegations against an individual for alleged spoofing-type conduct by his disgorgement of trading profits of approximately $8,000 US and a fine of approximately $82,000 US. According to IFUS, the defendant engaged in a pattern of trading from March 2015 to May 2015 in coffee C futures, where he would place small orders on one side of the market and large orders on the other side. On numerous occasions, claimed IFUS, quote, the small order transacted and the respondent would cancel the larger order on the opposite side of the market, end of quote. The defendant also agreed to a 10-day IFUS trading suspension to resolve this matter. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. Until next week, I'm Gary DeWaal. Ciao and play ball.